case to come before the court today is State of Ohio v. Nicole Powell. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know. I'll be keeping track of the time, and I will try to let you know when you move into your rebuttal time. The arguments are being recorded, so please stay behind the podium, introduce yourself, keep your voices up, and you should not use the names of children or minors or victims should that be relevant to your argument. You can refer to those individuals by initials or generic terms. We've read the briefs and we're ready to proceed when you are, and I would just ask counsel for the appellant, would you like to reserve time?
Yes, Your Honor. Dan Eisenbrei, on behalf of the appellant, I'd like to reserve 3 minutes for rebuttal, please.
Okay, very well. The time should also appear on this side monitor. The clock on the wall is a little bit fast, so don't pay attention to that. Pay attention to the clock on the monitor.
Thank you.
You may proceed when you are ready.
Thank you, Your Honor. May it please the court, my name is Dan Eisenbrei. I represent the appellant, Sydney Nicole Powell. There are 4 issues before the court this morning, any one of which amounted in prejudicial error and would warrant a new trial in this matter. But in the interest of time this morning, I'd like to focus my argument on assignment of error number 1, which relates to the denial of server rebuttal. In a battle of experts, which this case was, there is no room for unfair surprise at trial. This court has established that a defendant has an unconditional right to serve rebuttal as to new matters introduced in the state's rebuttal case. Despite this, 1 week before trial began in this case, defense counsel filed a motion asking the court for the opportunity to present rebuttal testimony in the event that the state called its only identified witness, Dr. Obradovich. Without any explanation, a week before trial, the court denied the motion.
Counsel, can I ask you, in that motion that you filed to be able to present rebuttal, you're saying it's pretty much a generic motion because at that point you did it just in case? Is that what you're saying?
That's correct, Your Honor. At that point, trial had not started, the state's expert had not testified, no expert had testified. But trying to get out ahead of the issue that the state may choose not to call any witnesses in its case in chief and instead reserve its sole expert for rebuttal, the defense counsel filed a motion asking the court to affirmatively permit rebuttal testimony. And the response was a blanket denial. And what this did, Your Honor, was it essentially green-lit the state to have the last word on NGRI and to be assured that its expert would not be challenged by another expert's testimony. This was particularly, really, in a case like this, it's all about experts, right? And even the state, in its opening, conceded that the only issue we're here before the jury on is whether the defendant was suffering from a severe mental disease or defect, and as a result, she could not appreciate the wrongfulness of her actions. This was not a whodunit. There was no dispute that Sydney's mother's death was caused by Sydney. The only issue for the trial was that of NGRI, on which the appellant carries the burden of proof. So what happened at trial was the state did not call a single expert, which, by the way, it only identified 1 expert. It did produce an expert report under Criminal Rule 16K, but that expert report turned out to not actually include many of the key opinions that the expert had testified to. In the defense case in chief, the defense called 3 preeminently qualified psychologists. Dr. Reardon, who was a former team psychologist for the United States Olympic team. He met with Sydney for 8 to 10 hours, put her through a battery of tests designed to decide, number 1, what her sanity was at the time of the act, and number 2, whether she was malingering at the time of the act or feigning, or in other words, faking a severe mental disease or defect. And Dr. Reardon concluded that he had rarely, if ever, seen a situation where an individual was in such an utterly compromised psychological state as Sidney Powell at the time of the offense. The state also called Dr. Swales. He's a forensic neuropsychologist. He was a professor at Case Western University, board certified, published. He spent 15 hours meeting with Sidney, putting her through these tests, which are recognized in the field of psychology of having merit. He's even taught a class to determine on the psychological test for detecting malingering. And he, like Dr. Reardon, reached a conclusion that at the time of the event, Sidney met the legal standard for not guilty by reason of insanity. And finally, the defense called Dr. Timmy, another psychologist who had testified in 100, provided an opinion rather, in 100 NGRI cases where the person he was studying was facing the risk of prosecution, criminal conviction, and in only 5 to 10 of those cases out of 100 did he come to the conclusion that the person he was studying did meet the legal definition of insanity. This was one of them. And the crux of all of these experts' opinions were through recognized testing in how do you determine if somebody was malingering at the time of the event? How do we determine what somebody's mental state was at the time of the event? On rebuttal, the state called Dr. Obradovich, and by contrast to the appellant's experts, this was her first time testifying at trial on these issues. She holds no memberships, not board certified, she doesn't teach. She spent just 2 hours with Sidney. The defense experts spent collectively in excess of 30 hours with Sidney putting her through these tests. And importantly, she ran no tests. And when she was on the stand for the first time, she attacked the methodology of the appellant's experts' tests. And this was the first time we heard this. She said, you know what, I didn't run any tests because those tests don't tell you anything about the time of the event. They only tell you about the time in which you were conducting the tests. That was not previously disclosed, and that is against the science.
And counsel, you were permitted to cross-examine Dr. Obradovich regarding that testimony, correct?
There was cross-examination by trial counsel, that's correct.
And is it the argument that without the SIR rebuttal, you were not effectively able to contradict or counteract that testimony? That the cross-examination allowed was not sufficient?
That's correct, Your Honor, because it's the first time we're hearing these opinions is during SIR rebuttal. Number one, it robs trial counsel, the opportunity to effectively prepare for cross-examination on new subjects. And number two, without having an expert being able to come and take the stand and explain to the jury the methodology of why what this person is saying is incomplete, I mean, that really goes to the fairness of this trial, and it allowed the state to have the last word on this, on new opinions that were not disclosed in the report.
I'm getting a little confused, so I'm going to ask you to clarify if you don't care.
Sure.
So the state did not put on their expert in their case in chief.
Correct.
They saved it for rebuttal
Correct.
In your case in chief.
Correct.
Okay. You did have a right to cross-examine them.
Correct.
And then, did they then have the right of rebuttal of that?
Well, so what happened after Dr. Obradovich testified is that trial counsel renewed his request to present SIR rebuttal testimony. He had a proffer about all the different points that were not listed in the state's expert report, including the points that go to methodology of the tests. And in light of that, he requested that he be permitted to call another doctor back to testify to the jury. The court stood by its previous decision under the rationale that you have had lots and lots and lots, quote, expert testimony in this case, and the judge did not allow the defendant to call an expert in SIR rebuttal. It is not the amount of expert testimony that counts. It is the subject of the expert testimony. So by denying the opportunity what that left us with is opinions that we have heard for the very first time on the stand, and they're going unchallenged by any other expert. And that's the last word on NGRI. And on NGRI, what we had is the fact that Sydney was diagnosed within days of the incident of schizophrenia and of schizoaffective disorder, within days. And she had been treated with a person who was not a paid expert in this case. She had been treating with a MD, with a psychiatrist for 3.5 years. He was prescribing her medication. She was responding to the medication. At the time of this trial, she was still under his care. He testified as a clinician that she, without any doubt in his mind, had schizoaffective disorder, which is a severe mental disease, and he had been treating her from that from just weeks, days, weeks after this incident. And there was no doubt in his mind that she was not making this up. There was nothing consistent with malingering. Contrast again to Dr. Obradovich. Dr. Obradovich says, yeah, I know these medical doctors have diagnosed Sydney with schizophrenia, with schizoaffective disorder, but she really doesn't have it. And this is all based on 2 hours and a review of some medical records. So when defense counsel pressed her on that and said, well, are you suggesting that she has been wrongfully prescribed medication for the last 3.5 years? Dr. Obradovich quickly backed off of that and said, well, that she's not qualified to render such an opinion. The state wants to argue that a lot of Dr. Obradovich's opinions that are at issue here today were really just in response to either cross-examination or to the other experts. First of all, they were not brought out in cross-examination. The record is clear that it was in the state's direct where you had the very first criticism of the fact that these tests that are widely recognized in the industry are somehow no good, and they don't tell you anything, because unless you do the test right at the time of the act or immediately after the act, then it has no bearing on mental state at the time of the act. And that is what these experts were robbed the opportunity to explain to the jury why that is. And what this did was it effectively put defense counsel in a position where he would have had to fight a ghost. He would have had to use his experts to say not only everything that he thinks the state's expert is going to say, but then in this case, it would be expecting him to come up with new things that are not in her report and try to preemptively rebut them. It does not work. It just simply does not work in this instance. And in doing so, it really made a difference in this case. It was not harmless error. Again, you had Dr. Obradovich was the only witness to testify that Sydney,
Counsel, you're moving into your rebuttal time.
that Sydney did not meet the definition of NGRI, and I will reserve the rest of my time for rebuttal. Thank you.
Good morning, judges. May it please the court, my name is Rick Fraley. I'm appearing today on behalf of Summit County Prosecutor Elliot Kulkovich of the state of Ohio, the appellee in this matter. I think it's important that this court not disturb the jury's verdict on appeal, overrule the assignments of error, and affirm the convictions. I will similarly limit my argument today. Appellant's counsel says it's about the first assignment of error. It seems like it also goes to the second assignment of error. So I will address primarily those two unless our questioning takes us elsewhere. And I do think that we need to add some context here. Although expert testimony was important in this case, I think there are some critical facts that have been left out of our presentations this morning regarding the defendant's conduct immediately after the murder occurred. Most notably that she staged the crime scene by breaking out a window, by opening the door, that she lied to her father and police officers about someone breaking into the house, that she even took on the victim's identity in a phone call with non-union officials. And that's a common sense premise that when someone takes such steps to cover up their own wrongful actions, they clearly appreciate the wrongfulness of their actions. And I cite in my brief to this court a wealth of case law holding that. It is just something that we innately understand, regardless of how many expert opinions may tell us that they have a different opinion on it. It is something that jurors are able to hear and consider. So with that, from there, I would just emphasize there are serious problems with the trial counsel's proffer statement about what he expected server to look like. It really amounted to an argument with his disagreements with Dr. Bradovich's testimony. The proper forum to litigate that and argue about that is in closing arguments. You don't get an automatic right to serve rebuttal, to represent evidence that's already been presented. And I put a chart in my brief, all the items that he outlines in his proffer, and the testimony from their experts that address those topics. And I would say that, these methodology complaints, those experts all testified why they used that methodology, why it was appropriate in their view, in their professional judgment, and why they thought that they were accurate results. Those were all before the jury to consider and for the arguments to go. It's clear there is no right to serve rebuttal. I can't ask for it today. There's no right to represent cumulative evidence and just be last. That's not the way our laws work.
Counsel, let me direct you back to one of the original questions I asked the appellant, and that was this first formal motion, the written motion, was he agreed that it was kind of like a generic motion. But it seems like the court just as well just kind of like banned all serve rebuttal instead of saying, as maybe most courts would, that'll be a topic we'll take up during trial.
Perhaps that would have been a better practice for sure. And it is something that certainly could have been reconsidered once trial occurred. And I believe there was a better proffer statement about, I want to call this witness who's going to testify exactly in response to this and what that witness is going to say. Perhaps the trial judge would have made a different judgment. However, the trial judge sat through weeks of trial, all kinds of expert testimony, hundreds of pages of reports that were admitted as exhibits. And the judge decided that based on everything she had heard in that case, that it was not something that was required to give serve rebuttal when they already had everything they needed anyways. So I would have preferred, yes, that the judge not had done that. I would have preferred that there would have been a less generic motion as well from the defendant, if there's going to be true pretrial litigation on this issue. But that was not where we are. What we did is we had a full trial, there were arguments, there was a proffer statement, and the judge still said, no, we're not going to do it now.
Well, an argument could be made that that was just a blanket policy of that court.
There's
that judge just doesn't allow it in general, which would be a problem, right?
That would be a problem. If there was a standing order to that effect, that would be a huge problem. However, nothing in the record indicates that it is a policy of this judge. And it turns out that she did reason. She thought there's lots of expert testimony on this, so I'm not going to allow it. She doesn't say ever. She says in this case, I'm not going to allow it.
And what does that mean that there's lots and lots of expert testimony? I mean, does that really matter? I mean, that seems to be irrelevant, doesn't it?
Well,
If your argument is that this was all new information that was brought in front of the jury.
I certainly would have preferred if she would have said, no, it's not new information. But I think once you go through the transcript, clearly it's not new information. Clearly the proffer was very self-serving. It was very generic and more of a disagreement. And that's not a basis for why you get an unusual remedy. I mean, serve rebuttal is unusual. I will say that, Judge. I won't say it's a policy where it's a blanket against, but it is something that is not typically provided in briefing and oral arguments. It's not typically provided in trials.
And this is not a usual case either, where you have 3 defense experts that are testifying.
Right, which I think would indicate that they have already put on their points. They have put on everything in the record that they have to argue for an NGRI finding. I think the problem, and this is getting to the second assignment of error, there's something that even common sense says. Clearly she understood the wrongfulness of her actions because of what she did, what we know she did. That's what the law recognizes. I mean, theoretically, the state didn't even need to put on any defense expert, a state expert, to respond to this because we can just point to everything that was happening. So, based on that, I think that the serve rebuttal evidence, we can't say there's abuse of discretion. The judge listened to this trial, she listened to proffer statement, she reasoned, and she said no.
Counsel, you don't have any disagreement with the qualifications of your expert?
No, I don't. That's not been an issue that's been raised. She was qualified as an expert. She did give her testimony. She explained why she found it was malingering, why she found it was not a basis for an NGRI finding.
But she said she didn't conduct any test on the liquor.
She did not explain that she did any testing. However, she explained based on her review of the records, her review of the interview with her the defendant's statements to her about minimizing, failing to remember the case, all indicated her malingering. It also is very important, I think, to note, psychotic symptoms were not recognized before this murder occurred. There was testimony from the defendant's friends indicating the night before she was very bubbly, I think was the testimony at a viewing of The Bachelor. There was testimony that there's no academic accommodation for intellectual disability in school. There's nothing in counseling records except for mild alcohol use disorder. There's only indication of maladaptive personality traits, which is not an indication of mental illness. So in terms of that is where Dr. Bradovich came from her opinions, and the jury heard that, and they agreed that based on what they heard in this offense, that it was inappropriate to NGRI.
Another question I have really quickly, hopefully, is in regard to her opinion, your expert's opinion, that you couldn't, that these tests were irrelevant and their testimony was irrelevant because you couldn't determine at the time that Sydney committed the crime whether or not she had schizophrenia, whether or not she was insane. Doesn't that kind of just throw out the whole not guilty by reason of insanity then?
I don't know.
Well, you're always looking after the fact. Every psychologist, every psychiatrist is making this determination. Obviously, you can't pinpoint. You weren't there to observe the behavior. You weren't there to do the evaluation as they're committing the crime.
And the jury essentially heard that from Dr. Reardon's testimony during the defendant's expert testimony. There may be circumstances where you can look after the fact and say, yes, at this particular time, this person was NGRI when they committed this offense. In this particular case, I think that that's not something you can find based on what Ms. Powell did after the murder. When we look at the exact facts of this case, what she did to cover up the offenses she committed, that screams, I know what I'm doing is wrong. Or else you wouldn't try to cover it up.
I guess my question is, did your expert testify that under no circumstances could you determine somebody who's NGRI based on their diagnoses after them?
I don't know if she explicitly testified that way. I think it was you just, in this particular case, you could not, based on what the record she looked at. Because I think if you went through and you saw records of psychotic symptoms demonstrated for years and years and years, perhaps there would be a basis for finding Ms. Powell. But in Ms. Powell's records, we don't see that. It only happens when the murder occurs, and that's also when the incentive to avoid criminal prosecution exists as well, hence the malingering finding. I would briefly like to touch on these issues about disclosures of criticisms. That seems like a State versus Boston claim. I have not seen that cited in the paperwork. It seems to be a bit of a different argument than what was made below or in the briefing on this. So I would say that that's something this court should steer clear of as a new wave issue. Again, this is something where there was significant expert testimony elicited by the defendant. They bolstered the credentials of their experts at the closing argument. The State responded with Dr. Bradovich and the sense of common sense about what we see in this case. The jury was able to find the defendant guilty under the circumstances and reject the NGRI claim. So if there's no further questions, I just ask you to affirm. Thank you, Justice.
Counsel, you'll have 2 minutes and 48 seconds on rebuttal.
Thank you, Your Honor. To respond to some of the points we've heard from the state, first, just briefly, it was discussed about Cindy's actions after the event here, and I would just say, again, these are pointing to actions taken after the fact. If you look at the state's experts' testimony, all three of them, the testimony wasn't that in their view, if you look at what she did, I mean, of all the ways to quote-unquote cover up a murder, I mean, this was so bumbling, it actually was consistent with somebody who was in a psychotic break. She was alone with her mother's body for 26 minutes after this, did no efforts to clean up blood, move the body. Her car was in the driveway, did not make any effort to flee. Instead, she takes a frying pan and goes around back and breaks a window, we think. That is consistent with somebody who is having a...
And counsel, did your experts or did defense experts testify to that?
Yes, they did, Your Honor. Yeah, and especially Dr. Tinney, if you look at Dr. Tinney's testimony.
And let me follow up with that. That goes directly, doesn't it, to, at the time of the offense, whether she understood the wrongfulness of her conduct, because why would anybody ever try to cover up anything if they don't realize that their conduct was wrongful?
Sure, Your Honor, and at first glance, that's what it appears, but if we take a deeper look, as again explained by Dr. Timmy, Dr. Reardon, Dr. Swales, it's not all or nothing when you're having a psychotic state. So there is no evidence of what she was doing or any type of extemporaneous evidence in terms of that 3.5 minutes. We know from phone records the attack lasted about 3.5 minutes. That is the 3.5 minutes that counts. The defense experts, there is evidence in the record to suggest that in their review, it's a waxing, waning, it's not all or nothing, and that was addressed in the reports. And the rebuttal, getting back to the issue before the court today, the rebuttal to that, again, we're talking about trying to undercut the expert testimony with opinions that were not previously disclosed, except for on the stand.
And counsel, I know you're running out of time, but I do want to just ask you, I want you to zero in on specifically what in your argument, what wasn't disclosed, where is that disagreement? Opposing counsel had mentioned that he put together a chart, so could you just zero in?
Sure, I think what this comes down to is the attack on the methodology. You're not going to find that in Dr. Obradovich's report, States Exhibit 19. You're not going to find any references to the attack on the underlying methodology. And without the defense experts knowing that another psychologist is going to come in and pull the rug out from established science and say, actually, all these tests that you spent 30 hours performing on Sydney are meaningless, there was no way for them to get out ahead of that and explain that in detail.
Okay, counsel, I'm going to have to ask you to wrap up.
Thank you, Your Honor. And in closing, what we had was an unacceptable surprise in a battle of experts hearing opinions for the very first time in the state's rebuttal case. This was ultimately served to undercut the defendant's fair trial rights. Justice demands a new trial, and we ask the court to vacate and order a new trial.
Thank you, counsel. Thank you both for your presentation. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to you on the day that it is released, and it will also be posted on the Ohio Supreme Court website. Thank you both.
Thank you, Judge.